So, in regards to naturalisation, this is covered by the British Nationality Act 1981, which is the last major nationality act that came into place. Naturalisation is via acquisition, sorry, and is based upon the Secretary of State making a decision. If you meet the requirements in terms of, which we'll go through in detail, full age, capacity, and the other requirements, whether you should be naturalised as a British citizen. It is via discretion. So even if you do meet all of the criteria, it is based upon the caseworker working on behalf of the Secretary of State to say yes or no. Obviously, if they do say no, then they should give reasons as to why they've come to that conclusion. So there's two main areas in regards to applying for naturalisation. One is based upon the fact that you're married to a British citizen, and the other one based upon not being married to a British citizen. So there's just a few different criteria you have to fulfill depending on which one you come under. So you'll hear me say about 6.1 and section 6.2. So 6.1 if you're not married to a British citizen, and 6.2 if you are married to a British citizen. So in terms of age and capacity, if you're applying for naturalisation, you should be 18 years old or older. If you're under the age of 18, then that means that you would be applying for registration. So naturalisation would not apply in your case. So any children that you have, if you're applying for naturalisation, they would apply for registration. In terms of capacity, the requirement is for the individual to be of sound mind at the time that they're making the application. The Home Office does have some discretion to waive this criteria. So if there is an individual that is not of sound mind, but in the circumstances it's the right thing for them to be naturalised as a British citizen, the Home Office can make a decision to grant citizenship. Normally, obviously, somebody would be filling in the form on their behalf to the best of their ability, and they would be explaining as to what the medical condition or their situation is, as to why they're not of sound mind, and the care arrangements that are needed for the individual, and why it would be in the best interest of that person to become British. Next section is good character. So in terms of good character, that is a general requirement throughout immigration, and it's there even more so for naturalisation. The Home Office will do their checks in regards to anybody that makes an application to them, and it is of the utmost importance that each individual declares everything that is requested on the application form. If you lie on the application form, that is a surefire way for them to not only refuse the application if they find out about it, but also ban you from making a subsequent application for up to 10 years. And even if you get to the situation where they don't find out about it at the time that they make a decision and they grant you citizenship, they can come back to you later on and say that you've provided false information or false documents and take away your citizenship. So it's utmost important that you're truthful from the very outset. It is actually a criminal offence to make a false declaration on a citizenship application, which can result in prosecution. So in terms of good character, most people normally think about criminality. Do you have any criminal convictions in regards to making the application? So again, you must give all details of criminal convictions if you have them, and that is for incidents that occur inside and outside of the UK. This includes road traffic offences as well. So if you have a situation where you're driving without insurance, driving without a license, those are still needed to be declared on the application form. Fixed penalty notices, so speeding tickets or parking tickets, they must also be disclosed. However, they will not normally result in the individual application being refused. However, if the person failed to pay the ticket, then it then resulted to go into court, then that can mean you then fall into the first category of it being a more serious event. If you have numerous parking tickets or fixed penalty notices, that also can be a reason for them to refuse the application. So even if you've paid all of them off, if you've had numerous, that can be a reason for them to refuse the application. So always check your parking ticket history. So going back to an actual criminal record, so in terms of how does it affect you making a citizenship application? So if you receive a non-custodial sentence, so that could be community service, a fine, for example, then normally you would have to wait for at least 3 years before you can make the application for naturalization. If you received a custodial sentence of up to 12 months, then you would normally have to wait for at least 10 years to have passed before you can make the application. And that moves up to 15 years if it's between 12 months and 4 years that you've been in custody. And if it's been more than 4 years, sorry, 4 years or more, then normally the application would be refused. So regardless of what time has taken place, they would normally refuse the application. However, you will note that what it states on each category is that it will normally be refused. So there is room to put forward an application and argue as to why you should be granted citizenship, even though you fall outside of the criteria in terms of the time passed. So we do a lot of applications where people have committed criminal offences and they're applying before they've served their 10 or 15 years or 3 years of good character, but it's always done on a case by case basis. Other good character considerations outside of criminality, they look at HMRC. So if you've paid, you have to make sure you've paid your national insurance and income tax. Mainly, this is applicable to self-employed individuals. If you are self-employed, your most recent self-assessment should be submitted with the application. If you have a deportation order still in place, your application would be refused regardless of how much time has passed. And they also look at civil judgments as well. So if you've had civil penalties under the UK Immigration Act or you've been declared bankrupt, that can be a reason for them to question your good character. If your bankruptcy is undischarged, then again, it's likely to be refused on that basis. Other good character issues is immigration related issues. So if you have got your indefinite leave to remain and you're eligible to apply for citizenship, but in the 10 years before you apply, you were involved in any kind of deception with the Home Office, that could be providing false information, providing false documents, then again, you'd normally have to wait for a 10-year period after that has ended. And if you've helped somebody to evade immigration control or employed illegal workers, again, that can be a reason to refuse the application. But as I've tried to say throughout, it is normally, so there is room to maneuver in trying to persuade the Home Office to grant discretion in your favour. So the next aspect is the English language and knowledge. You will, after I've spoken, have a short talk with the Trinity individual that will explain about the B1 test that they offer. That is the level of English language that they're looking for when you're applying for citizenship. So that can be met by taking English language test, which you can do at Trinity, or it can be based upon the fact that you have a bachelor's degree or higher, either taught in the UK or if taught outside of the UK but in English, then a company called NARIC that has just changed their name actually to ENIC, they would have to verify the degree meets the UK standard. Or if you're from English speaking majority country like the US, for example, or Australia or New Zealand, you'd meet the requirements that way as well. And you are exempt from the English language requirements if you are 65 or over, or if you have a long-term physical or mental condition, which means that you are unable to take the test. You also have to do the Life in the UK test, so that's in regards to your knowledge of the UK. I think the pass rate is 75% that you have to meet. And again, you have to pass that before you can make the application for naturalization. The next requirement is making sure that the UK will be your main place of residence after the application is granted. So it has to be your intention that that is the situation. If at the time you're applying, you know that you are not going to be living in the UK anymore, you're going to go overseas either for job or for any other reason, then that can be a reason for them to refuse the application. And this may be something that they find out at the time of the application, but it could be something that they find out after the application has been decided upon. So it is important that your intention is to be in the UK after it's been granted. Obviously, if you're on Crown service, then they'll take into consideration that you're being posted abroad, for example. In terms of the next requirement is it's kind of a, how do I say, a strange point, but it's one of the things that an application can be refused upon. So under the residency requirements, if you are married to a British national, they will look at your last 3 years of residency. If you're not married to a British national, they'll look at your last 5 years of residency. Now, what they are wanting to be in place is that, let's do with not married to a British national, 5 years prior to you applying, you were physically in the UK. So I've given an example on the slides. So if the application is received on the 5th of January 2022, then the individual should have been physically present in the UK on the 6th of January 2017. So 5 years prior to the date of the application. If you were on holiday or for whatever reason were outside of the UK 5 years before, again, that can be a reason for them to refuse the application. So it's always important to count back whether you were on holiday at the time you're looking to make the application. So as I said, if you are not married to a British national, then they are looking for no more than 450 days in terms of absences in the last 5 years before you apply. And if you are married to a British national, they're looking at no more than 270 days in terms of absence in the last 3 years before you make the application. So is there any room to maneuver in terms of the amount of days that you've been absent from the UK? So yes, there is. There is some flexibility in regards to that. So with the 5 year qualifying period, so on the basis that you're not married to a British national, 450 is the normal permitted days. They will normally disregard 480 days without too much more inquiries, but they can actually disregard up to 900 days. So that's actually double than the 450 days. So if you're absent for 900 days in that 5 year period, there could be discretion exercised in your favour. So they normally expect that you meet all the other requirements for naturalisation and you've established your home, family, and a substantial part of your estate in the UK. If you're looking at up to 730 days, they'll normally expect you to be in the UK for the last 7 years in total. And if it's more than 730, then at least 8 years in total. If you are married to a British national, then they look at the 3 year qualifying period. So again, 270 days is normal. 300 days they would normally disregard without question. And then they can again do up to 540 days. So again, double the amount in a 3 year period. Again, on the basis that you meet the other requirements and you've established your home, family, and your estate here. If you've been absent for more up to 450, they'll expect you to be here for at least 4 years. And if you've been absent for more than 450, that you've been here for at least 5 years. So traveling in and out, again, can still, it may not stop you from making the application and being granted. The second absence requirement is the year before you apply. So 12 months before you make the application, the standard requirement is that you do not exceed 90 days in that last year before you make the application. And this is the same for whether you're married to a British national or you're not married to a British national. Do they have any discretion in regards to that 12-month period? Yes, they do. So again, 90 days is the standard. 100 days they'll normally disregard without too much questions, but they can actually disregard up to 179 days. So nearly 6 months in the 12 months before you apply. So again, they're looking at, has the person demonstrated links to the UK, family here, establish a home here, your estate, are there any compassionate circumstances, has there been any element of Crown service overseas? So again, on a case-by-case basis, just because you've exceeded more than 90 days, there can be still room to maneuver. And it could be a situation where we're in now, where there's been a pandemic and you've been stuck overseas for whatever reason, because of border closures and flight cancellations. If that kind of case is put forward, discretion could be exercised in your favour. I think somebody's still not on mute. Okay, thank you. Okay, so the next requirement is that you are free from restriction at the time that you're making the application. So that's on the basis that you have your settlement in the UK. So normally it's called indefinite leave to remain, okay, at the time that you apply. If you are not married to a British citizen, then you would normally have to have that indefinite leave to remain for at least 1 year before you make the application for naturalisation. If you are married to a British citizen, then you can make that application straight afterwards. So if you've got your indefinite leave to remain today and you're married to a British citizen, you can make the application for naturalisation tomorrow. Okay, you don't have to wait for that 1 year period. That's only if you're not married to a British national. So indefinite leave to remain includes those that have been granted under the EU settlement scheme, so for EU nationals and their family members. Permanent residence card, which was under the old European law. Those are still valid at the moment up until the 30th of June 2021, so you can still rely upon it up until that point. If you have the permanent residence card and the indefinite leave to remain, then you can rely on either one of them up until the 30th of June. After the 30th of June, then you would have to rely upon the EU settlement scheme indefinite leave to remain. Okay. So you have to ensure that you're not in breach of immigration laws in your qualifying period. So this is different to the good character. So as I said before, good character, they will look up to 10 years, up to the last 10 years. If in regards to the qualifying period, they're looking at the last 5 years, if you're not married to a British citizen, or the last 3 years, if you are married to a British citizen. So they expect you not to have breached any of the immigration laws during that qualifying period. So a lot of this impacts EA nationals and their family members more so than other nationals, because other nationals will normally have continuous residency before they're granted their indefinite, for them to then go on to naturalisation. If you are an EA national or a family member, then you have put into 2 different schemes in the last few years. You've been under European law, and then when Brexit happened, you are under now the immigration laws, which is under the EU settlement scheme. So there are situations where an individual has been granted indefinite leave to remain under the EU settlement scheme, and the Home Office would look at what happened before they were granted their indefinite leave to remain under the EU settlement scheme. It was a requirement under EU law for individuals that were EU nationals to be exercising their treaty rights. And that means they had to be deemed a worker, a student, self-employed person, self-sufficient, retired, or a person who was incapacitated. So before you got your indefinite leave to remain under the EU settlement scheme, you would have to have fallen under one of those categories. So if you did not fall in one of those categories, then you would be considered in breach of immigration law and therefore not eligible to apply for naturalization. So if the time frame of your qualifying 5 years includes time before you got your EU settlement scheme settled status, you have to make sure that you were one of these in that 5 year period. Otherwise, the application would be refused. I know that's a little bit complex, and again, this is something that IS deal with on a day-to-day basis. So if there is any confusion regarding that or needed help with these kind of applications, then this is something that we can assist with. So the next point is referees. So 2 referees are needed with the application process, and they will need to confirm your identity by signing a form as part of the application. Each referee should have known the individual for at least 3 years. One referee has to be a professional. I've put the link here in terms of the listed professions, but it can be, for example, like a nurse, teacher, lawyer, doctor, police officer. I think there's accountant, architect. Those kind of professions are on the list. That person can be any nationality. They don't have to be British. The second person should be British and over the age of 25. Okay, but both have to have known you for 3 years or more. They must not be a relative by blood or marriage. They can't be acting for you as your solicitor as part of the application. They can't be related to each other, so each referee has to be separate. They can't be husband and wife, for example. Not be employed by the Home Office, not committed any offences during the last 10 years as per your requirements for the application, and they have to have known you personally. So they should be able to identify you from a passport photograph. Okay. So the referee just has to sign a form. So your photo would be attached here, and they're confirming that they've known you, and then they will sign at the bottom to confirm that information. You also need to submit evidence of your identity for the application. So normally that would be your biometric card if you've been issued one, alongside your passport, your national ID card, could be your birth certificate or other Home Office document that's been issued to you regarding your status. Sorry. If you have used a different ID to take your life in the UK test, then you also have to make sure that document is presented at the time of the application. So if you lose your driving license for your life in the UK test, then you have to submit that as part of your ID documents for the application. So what is the application process? It's an online application form now, which is the most straightforward option at the moment. The application is submitted online. The application fee at the current time is £1,330. The Home Office confirmed last week that the fees haven't gone up this year, so we'll wait till the end of the year or next year to see whether that changes. There's a £19.20 fee as a standard for your biometric appointment, and you'll be required to enroll your biometrics as part of the process, and that's for all applicants. Whether you're EU national or non-EU national, your biometrics have to be taken. Your supporting documents are uploaded online, so you don't have to physically send your documents to the Home Office, and you don't have to physically attend your biometric appointment with your documents. There's an online portal that opens up after you submit the application, and you upload your documents that way. Can you travel while the application is pending? Yes, you can. Obviously, you need to attend your biometric appointment, but there's no restriction on you traveling while the Home Office are making a decision on your application. After you attend your biometric appointment, you have your passport. Before you attend your biometric appointment, you have your passport. In terms of time frame, normally it's up to 6 months for an application to be decided. That was pre and post COVID times. There are some delays in the system because of COVID. I would say the main delay at the moment is actually getting a biometric appointment. It normally takes about 3 or 4 weeks now to get an appointment rather than 3 or 4 days. Um, but normally up to 6 months is the decision making time frame. Um, in terms of the decision that comes through, normally, again, because of COVID, it will normally be a letter that is, sorry, an email that is sent through confirming that the application has been granted. A letter does get sent out occasionally, and then you'll receive a second invitation letter from your local authority, and that's in regards to you attending a ceremony in the UK. Normally in your local, normally in a local area, unless you've indicated that you want it to happen somewhere else. So when you attend the ceremony, that's when you will obtain your citizenship certificate. So that is when you are considered as British. Any time before you attend the ceremony, even if the Home Office have granted it, you are not British until that certificate is in your hands. Okay, so there are some instances where, especially with COVID, you get the approval letter from the Home Office, and it can take another 3 or 4 or 5 months to get the invitation letter from your local authority. If you commit a criminal offence, for example, in between that time frame, then they can withdraw the approval because you're not British until you get the certificate. There's also the fact that because of COVID, some of the ceremonies are online via Zoom at the moment, and then you'll get your certificate through the post. But that's the process in terms of getting citizenship via naturalization.